question that we do have, it dropped in a couple of times. Kate, perhaps you want to have the first go of this. It's a two-part question, and Matt, you're more than welcome to give your input as well. And the question is, what if I were to set up a QOF and invest in it, and then at a later date I was to contribute some more cash for an identical interest within that qualified opportunity fund? If I were to then sell my portion of the interest, how do I keep track on how much interest I have sold in that fund? And with that respect, are there any best practices for investors coming into an opportunity fund that perhaps we may not have touched on during the presentation today?
Yeah. So in that case, you'd essentially track this per the Treasury Regs 1.1012-1C rules. And if the taxpayer doesn't adequately identify the interest sold, typically the default would be a first in, first out, so FIFO default rule with respect to what you're actually selling. So you want to track this. You want to know what's going on for purposes of holding period, and then the type of gain too. So that's something we should point out, is the eligible capital gains that you defer into the qualified opportunity fund retain their character for purposes of that when they're recognized either at the earlier of the inclusion event or 2026. So if you invest short-term capital gains, just because you're waiting till 2026 to recognize them doesn't transform them into long-term capital gains. So that's going to be important too. So for purposes of tracking what kind of capital gains you recognize if you dispose of your QOF interest and it's an inclusion event and you have to recognize some of your capital gains, you'll be able then to identify, oh, these are the short-term ones that I invested, or oh, these are the long-term ones that I invested. So it is important to track all of that.
Thank you so much, and Matt, maybe some best practices from yourself as well, if you can think of any as well. Best practices when it comes to investing in a fund from the perspective of the investor.
Sure. I think the best practice here is to always remember that, unlike a 1031 exchange, in which you are investing in most of the time, almost all the time, a fully developed, somewhat leased or fully leased building in any particular economic area or region of the country. The OZ program is designed to go and, again, encourage long-term development, meaning new development, in low-income communities, which means that you are talking about largely on the real estate side, ground-up development. And just because you get the benefits of the Opportunity Zone program potentially in a deal, and the tax advantages are great, that does not mean that any particular investment makes economic sense. You have to look at the developer's track record, the project, and do your due diligence on the real estate and understand the investment in of itself and analyze it as a ground-up investment. And in many instances, especially clients that are selling businesses or selling art or selling stock, these are not investors that are experienced real estate investors, which is tough enough in of itself, but you're putting them into investments that are challenging in many, many instances. So you need to fully vet those projects with your client and make sure they understand it. And in many instances, have a relationship and vet out the developers who are responsible for developing the property as part of this. Again, it's all due diligence, and there's a significant number of factors that you need to go into and evaluate as part of this. And I'm not even getting into the business terms of the deal, but your clients have to fully understand and appreciate the unique challenges of investing in ground-up developments in opportunity zones and what that entails. And like I said, that's very different than a 1031 exchange.